Hi, my name is Justine Johnson, and today I will be presenting on tort law and specifically in the educational setting. Tort law is basically a civil wrong that causes someone to suffer loss or harm resulting in legal liability for the person who commits the act. Commonly, this can be found in negligence cases, malpractice cases, especially in someone that has suffered from physical harm like battery or assault, false imprisonment, intentional infliction of emotional distress. So this is basically anybody that goes through emotional distress, maybe mental distress, damage to property, and trespassing can also fall under tort law. I noticed in the educational setting that the majority of the time cases fall under negligence. The first case that I analyzed was in the Anchorage school district. And in this case, a kindergarten boy left the classroom. He was really excited to show his mom a piece of art that he made, and he ran up to her, fell over a stump and into a pile of pine needles. One of the needles penetrated the child's eye socket and actually damaged his brain. The child suffered permanent brain damage, including the ability to sense hunger, body temperature. He suffered through major fevers because he wasn't able to regulate his body temperature. He gained 50 pounds in the span of a month because he was just constantly hungry and his brain was no longer to know when he was actually hungry. He just always felt the need for hunger. His hippocampus was affected and so was his memory, and so the parents felt that a lot of the things that he was learning, he wasn't able to remember the next day. The Anchorage court found that the district was negligent in this case, and they paid the family $4.5 million in damages and emotional distress by the parents. This case is just super sad. It's something that happened, but what I learned from it is that the school district and the school especially really needs to make sure that there are no safety hazards on the playground. As a principal, I would make sure that the field maintenance, the maintenance staff in general, is constantly providing safety checks, especially just with children out on the playground all the time. You can't have any hazards like this. And I would make sure that I'm looking up the playground requirements and the laws and adhering to them. I know at least in the early education setting, there's licensing that comes out, and they purposefully do any type of licensing safety check. This could be once, possibly even 2 to 3 times a year to make sure that it is safe. And as well as the fire department, they are also out to make sure that the playgrounds and other places are safe. As a reactive measure, I would go through any type of licensing report, fire department report that I had, remove any unsafe hazards immediately, conduct another safety check, and reach out to anybody in my district. Another case that I studied was Hoyam versus Manhattan Beach City in California. This was a case where a 10-year-old boy was attending summer school and he left the school premises before the day was over. After he left the school, he was at an intersection and was struck by a motorcycle. The family alleged that the school district failed to exercise care in supervising a student while the student was on school premises. The school district was found that it did breach duty of care and that negligence was a factor in the student's injuries. I noticed that a lot of the cases I studied did have students that were leaving the school premises, and this is when the majority of incidents occurred. It was also very tricky water just because the student was not in the school's care. However, they were leaving, and so the lines get a little bit blurred in who is responsible for that student. As a principal, I would just develop policies and a code of conduct that informs parents immediately when a student leaves the premises. If a student does leave, I would keep someone in their line of sight. Make sure that someone from your staff, whether that's a dean of students, a principal, assistant principal, is following the student and has a line of sight on them at all times. I would also call the law enforcement or any school-related security when a student leaves the premises and inform them, just to be sure that this student is in someone's care or at least someone's line of sight if this does happen. As a reactive measure, I would review any policies and procedures in my district or my school, reach out to personnel and public relations, obtain statements and documentation from teachers and support staff, and review any camera footage if it is available. The third case that I studied was Mitchell versus Cedar Rapids, and this was another case where a student left the school premises. This student was in high school, and so I do understand that it can be a lot more difficult for a high school to maintain a line of sight on a student, but this student was in special education, and she was a 14-year-old student. According to her IQ test, was functioning at about a third grade level. This case was also very tricky just because she had called her mom and asked her mom if she was able to ride the bus home with one of her friends. Her mom said that yeah, that was fine. But the student, her name in the case is DE, actually skipped her 6th period and left with a boy. Teachers had stated that they had seen these two students have romantic relations, but that was normal in a high school, and so they didn't think anything of it. When the student did not show up to her 6th period, the teacher did document it in attendance, and the district policy was that phone calls were made home that evening through an automated system to inform them that their student had been truant. When the 14-year-old girl left with the 19-year-old boy, they walked home to his grandparents' house, but decided to stop at a friend's house. And while they were in the friend's garage, the 14-year-old girl was sexually assaulted and raped by the 19-year-old student, and the friend had also shot a BB gun at her. This all happened when she was truant, and then she went home after and actually ended up telling her mom about it shortly after. This case was extremely tricky just because she was on an IEP. However, that IEP did not state that she needed to be escorted to and from her classes. And so the school district was arguing that they were not held liable because of the school policies, that they did inform parents and call them through an automated system, that they did document her absence. However, the state of Iowa awarded $500,000 in damages and said that it was 70% fault to the high school Kennedy. The high school actually appealed this, and it was taken to a Supreme Court where they did agree with the original ruling. It's the parent sued Kennedy for negligence individually and on the student's behalf for failing to adequately supervise and to not report in a sufficient amount of time that her student was truant and absent from school. That they didn't provide security to prevent special education students from leaving, and that they didn't have an adequate monitoring system for students. As a reactive measure in this case, I would review any policies and procedures for when a student leaves school premises. I would also obtain statements and documentation from the special education teachers, from any students in that class, from parents. I would review camera footage if it is available, and contact the district about policies and the automated attendance phone calls. As a proactive measure, I would provide phone calls to parents of all special education students' families if they are suspected truant or absent. I think this is extremely important just because a student that may be 14 but that's functioning at a third grade level. You don't know if something could have happened to them, if they were safe, or if they were suspected to be skipping school. I would hope that in special education classrooms that the teacher to student ratio is a little bit lower and have a paraprofessional or someone that is in charge of making phone calls to parents and just knowing exactly where a student is, and if they are suspected truant, that someone is immediately notified. I would just implement a system altogether that if a teacher is marking absent on any student in the school, that families are automatically notified. I know that there's programs out there, and I would invest in one that if a student is marked absent, it sends an email or text message to the parent and notifies them immediately that they are truant or absent, because I've just seen a trend so far in these case studies that a lot of terrible things are happening when students are not in school. The next case that I reviewed was in Atlanta, Georgia. A teacher left her classroom to use the bathroom and was unattended. She asked another teacher to listen out for her class. While she was gone, 2 boys were roughhousing, and one student landed on another one and dislocated his collarbone. This cut a major blood vessel, and the student was rushed off by EMS and pronounced dead at the hospital. The parents were suing the teacher for wrongful death based on negligence because the students were unsupervised when she left the classroom. The teacher initially reported to the principal that she did not leave the classroom, but it did come out later that she did, in fact, leave the classroom. The teacher was not found negligent based off of discretionary act and personal judgment, which gives her official immunity from supervision of the classroom. As a reactive measure, if I was the principal, I would obtain any statements immediately, and I would also file a report through whatever system or policy my district has for the teacher violating that. I would review all of my policies and procedures and react accordingly. As a proactive measure, I would implement a policy where teachers dial the office and a specified person will step in when the teachers have emergencies, because I do understand that this does happen, but students cannot be left unsupervised. I think just having a code of ethics and having a policy that specifies what teachers should do and can do if they need to step out of the classroom could prevent something like this from happening. The last case study that I found was a bullying case. An elementary school student was pushed down the stairs by another, and it resulted in permanent paralysis. The parents argued that the school was negligent because staff had been informed about bullying before and didn't have any anti-bullying policies. This case actually eventually went to the Supreme Court, and they found that school districts are not liable in a negligent claim for any action caused by a third party. Bullying is becoming a big issue in today's schools, and as a proactive measure, I would just make sure that I have a policy, our school and our district has a policy against bullying and a code of conduct. I would also implement a school-wide social-emotional curriculum, just because I think it's found that it can help with that. And I would also use any school-wide behavior data to target any trend, so that way if there are issues among students and bullying, that we're just trying to prevent any issues like this in the first place. As a reactive measure, I would review policies and procedures for bullying by the school and district. I would obtain statements from teachers and students, review camera footage, and review if there is any documentation of previous bullying or altercations. Throughout this case study, I use these references. Thank you for taking the time to review tort law and education.